Lakshmi sir, are you able to hear me?
Yes, Amrita.
Yeah, that order after Bhavna, who's it?
The order first is Faisal,
Then Bhavna.
then Bhavna, yeah,
Third one,
then
Anthony.
Anthony,
Okay, okay.
and then Dr. Akil Pragya. This is for introduction, all of
Ah,
you. We should.
A continuous interference is going on. Is it with me only, or everyone is facing this?
What is the sound of air?
Yes,
Uh,
it's some sound of air. Yeah.
yes, yes.
I think if everybody mutes, then it should become all right.
Okay.
I think it's from Amrita's desk.
just a minute, sir. Is my presentation visible? Hello?
Yes, your screen is visible now. Yeah.
Yes.
Not this screen. I think the presentation is not able to be one. But I am not able to see anyone. Is it? You are able to see me? Screen is visible there.
Yes,
Yes,
it's
yes,
visible.
Amrita.
Yes,
Yeah.
yes, yes.
Yes.
So, yeah, good morning, all of you. I welcome you all for this panel discussion on patent protection and enforcement. I thank the sponsors, Singhania partners, for coming in association with us and making this a great program. I also thank the Intellectual Property Facilitation Center in Gujarat for giving us a great support in delegate participation. So TNTDPC is a society which is formed in 2005 jointly by the Government of Tamil Nadu and Confederation of Indian Industry. As you may all be aware that CIA is presently involved in facilitating several initiatives towards relief and rehabilitation and policy interventions with the central and state government. In the challenging COVID times, we are happy to host this kind of challenging program in specific to intellectual property. To briefly introduce about the moderator, Mr. Lakshmi Narayanan from Samsung Electronics. He is the director and head for intellectual property and innovation management. To say about Mr. Lakshmi, Lakshmi is responsible for championing systematic invention, creation, securing and enforceable patent protection and building high quality patent portfolio for Samsung in India. Lakshmi has been serving in the field of IPR for over 20 years with specialization in patenting of software technologies and management of large global patent portfolio. Lakshmi is a graduate in mechanical engineering from the Institution of Engineers LLB from Karnataka State Law University and also LLM in Business Law. He is registered to practice before Indian Patent Office since 2002. During Lakshmi's IP leadership, Samsung Bangalore R&D Center became top patent filing company in India in IT sector and top patent grantee in India from inventions made and first filed in India. Samsung's Bangalore Center won National IP Award, WIPO IP Enterprise Award, then Great Place to Innovate Award, Samsung Special Awards, Confederation of Indian Industries IP Award, National IP Award, Asia IP Elite Award at Tokyo for the best mobile and telecom IP in Asia. Lakshmi was featured in IAM Strategy 300 as world's leading IP strategist for the fourth successive year by the reputed intellectual asset management business platform. He was also featured as young intellectual creating a difference in India by the reputed Snans IP blog. Welcome, Mr. Lakshmi Narayanan, on board for this wonderful program. I hope this program will be a good, enriching experience for all the young IP people. And thank you for joining us. Over to you, Mr. Lakshmi.
Thank you, Amrita. Welcome all of you for this webinar on patent protection and enforcement, global perspective. We have very eminent panelists here. I'm honored to be joining this panel and introducing our panelists one by one. Welcome, Faisal. Faisal heads the IPR department in L&T Technology Services, and he advises about 14,000 employees on patent protection, enforcement, and strategizing invention creations. Faisal is listed among the top 50 emerging IP players in USA, Germany, Singapore, Australia, Dubai, and India by the IPR Gorilla and among top 100 IP leaders in India, the World IP Forum. He is expert in IP asset management, IP commercialization, IP infringement monitoring, licensing, and IP due diligence. Welcome, Faisal, to this conference.
Thank you, Mr. Lakshmi.
Thank you. Welcome, Bhawna. Bhawna is a patent practitioner and also design practitioner with over 10 years of experience, with expertise in drafting, securing, protection, and enforcement of patents and design rights across multiple jurisdictions. She advises many Fortune 500 companies, some of the most esteemed corporations, Indian R&D sector and inventors, especially the medium and small scale industries. We are going to hear great insights from her on the small scale industries and the strategies. Welcome, Bhawna.
Thank you very much, Lakshmi.
Let us welcome Anthony Topman. Anthony comes from World Trade Organization. He is a director of Government Procurement and Competition Division in the WTO, and he has also worked earlier in the Intellectual Property Division of WIPO. And earlier, he has worked with the Australian Department of Foreign Affairs and Trade as a Director of International Intellectual Property, engaged in multilateral and bilateral negotiations on IP issues, domestic policy development, regional cooperation, and TRIPS dispute settlement. We are going to hear more about him today from the TRIPS perspective and the global perspective. He is also a teacher in the international IP law in the Australian Centre for Intellectual Property in Agriculture and College of Law at the Australian National University as one of his career. Welcome, Anthony, to this webinar.
Morning, and thank you very much for the warm welcome. Greetings from the shores of Lac de Bourget in France. Where it's sunrise at the moment. Good to join you.
Thank you, Anthony. We have Dr. Akil Prasad with us today. Dr. Akil is the Director, Country Counsel, India and Company Secretary with Boeing India, and he is based at New Delhi. He has held offices as Head of Legal and Company Secretary with Fidelity Worldwide Investments and also Director, India Legal Affairs and Company Secretary for the Walt Disney Company. And not just that, he has also held top legal positions with Electrolux, Modi Xerox, Graftech, and Akil brings 25 years of experience as in-house counsel and has worked with legal teams spread across different countries. Welcome, Dr. Akil Prasad, to this conference. Akil will share insights on importance of IP as well as the enforcement strategies with national interest. Welcome, Dr. Akil.
Thank you, Lakshmi. Thank you, everybody.
We have Pragya Chaturvedi with us. Pragya is Senior Intellectual Property Advisor and represents UK Patent Office in India, UK Intellectual Property Office in India, with the British High Commission, New Delhi. Pragya provides assistance to UK businesses with local IP issues in India and collaborating with various government entities on raising the IP awareness. She advises regional BHC colleagues, the British High Commission colleagues, to implement projects in accordance with the UK Intellectual Property Office objectives. Welcome, Pragya, to this conference.
Many thanks, Lakshmi. It's wonderful to be here and to be part of this great panel. Thank you.
Thank you, audience. Welcome, audience. Let's go into the panel discussion now. The panel is structured in three phases. The first phase being the importance of intellectual property or patents from several perspectives. And then what is the enforcement strategies available? And then we get to know what are the initiatives at the India level, at the global level, to promote intellectual property creation and then balance the importance vis-a-vis the enforcement challenges. Patent is the form of intellectual property which is usually talked more in IP conferences. In the past, we were all believing patent is important for developed countries. Of late, we have started believing it is very important for developing countries. But now it's neither developing nor developed countries. Today we are talking about the current situation, the pandemic situation, which is COVID-19. Let us ask Pragya, given the COVID situation, what is the importance of intellectual property, especially patents? Over to you, Pragya.
Thank you, Lakshmi. So I will talk about it in the context of the challenges and also opportunities that have emerged or have become very prominent in the wake of this situation. So first up is trademarks. They undoubtedly serve a very important distinguishing function. That's why they're important for every business. But in this situation, we have seen a significant increase in counterfeiting in terms of medicines, masks, even disinfectants and sanitizers. So while it is not only harmful in terms of the monetary loss to the customer or the loss of reputation or reputation damage for the business, uh, this kind of counterfeit products can have an actual adverse impact on health. And that's why in this particular situation, enforcement, protection and enforcement of trademarks is even more significant and more important. Then coming to patents also, they are of course vital for other sectors as well, but when it comes to healthcare, they have even more increased importance because of a couple of factors. So first is the amount of risk that healthcare companies undertake. There's only 1 in 20,000 molecules that are produced as a result of the research to produce a medicine. So only one out of these 20,000 molecules actually reach the market. So there's a significant amount of risk a healthcare company undertakes when they invest in research and development of a particular drug, because while investing, they don't even know if the molecule that is being developed will actually reach the market or not. Then another factor is the nature of this risk. The nature of this risk that healthcare companies undertake is linear rather than distributive. So what that means is that the risk that these handful of companies undertake for investing into the research for developing a particular drug is concentrated in a couple of entities as opposed to a large number of companies for any other sector for that matter. And studies have consistently shown that patent system appropriately rewards that risk that these entities undertake. Then opportunity cost is another factor here. There is a huge opportunity cost that goes into investing the research and development in the healthcare field, and that opportunity cost is very high, and that can be adequately rewarded through patent. Coming to another aspect of this is data, both personal and non-personal data. This COVID-19 situation and the data collection for contact tracing and other health-related services has sparked a lot of debate around the regulation and protection of data. It has also sparked some privacy concerns. So India has both personal and non-personal data committees. They have formulated these draft reports on regulation of both personal data and non-personal data. I will not go into the one on personal data because that is largely based on privacy concerns. But the draft report on non-personal data does raise a few points related to intellectual property. For example, it talks about the need for a robust IP framework to promote data innovation. It talks about ownership of data. It also talks about mandated data sharing in certain situations. And within that data sharing, it also speaks about data sharing on FRAND basis in certain situations. So a FRAND is a term used mostly in in relation to standard essential patents. It stands for fair, reasonable, and non-discriminatory terms. The draft report, which talks about regulation of non-personal data and sharing of this data in certain situations on a FRAND basis, it has understandably raised concerns from several stakeholders, several questions, several concerns. For example, when it comes to standard essential patents, this is largely FRAND is a voluntary action. But here, when we talk about it in a regulated format, then there is a lot of I would say ambiguity there, because it's not clear whether there will be guidelines issued for determination of this of what this FRAND remuneration is, and whether since it's a voluntary action. Otherwise, if it will be mandated through a regulation, what impact will it have? What scope will it have? So these are largely the concerns of different industry stakeholders. So here at the British High Commission, my colleagues who are leading on data and myself, we are working closely with the with India's non-personal data committee to provide our inputs. And recently we had a large consultation with different stakeholders from academia, from industry, from the legal profession, and many businesses also, which rely a lot on data. And we have recently submitted our collated inputs to the non-personal data committee for their consideration, in which includes IP consideration. Thank you.
Thank you, Pragya. I think you set the right context by bringing in three important forms of intellectual property. The trademark in this COVID period sees a lot of counterfeits. If it is patent, then companies have to balance the opportunity versus investment risks. And there is also a need to handle data with a proper framework. Let's ask Faisal, from the technology services perspective, why, Faisal, do you think, or what is the importance of patent protection?
Well, technology service business is something where you most of the time work for other companies. And as per work made for hire clauses or otherwise based on the contract, the intellectual property stays with the customer or with the company for whom we are working, for whom you are going to work for. So in that scenario, it's very difficult to to secure anything for yourself. Uh, and the business largely depend on the work which you get from your customers. So in case the work, in case you don't get the work, or in case there's a situation like currently COVID situation is going on, the businesses are going down. So it has a direct impact on the companies like us, which provide technology services to other companies. So even if you have the manpower, even if you have the resources, you are not able to work because you don't work for yourself, you work for other companies. And because the nature of your work is like that, that you don't pick your intellectual property for yourself, then it became very difficult to have, or have any thing with you which you can use or utilize in the market in case you don't have the services. So it's very important for technology service companies. We as an L&T technology service company, we realized it for ourselves, and then we started looking into the areas where we can utilize our manpower to develop some IPRs or secure some IPRs in the field where we do not contradict or do not affect our relationship with the customers. Another important aspect of the work for a technology service company is uh, it's very difficult to differentiate between what is customers' intellectual property and what is your intellectual property when you work for project with them. At times you may be working in their facility. At times they may share their resources or their IP and the resources with you. Uh, so it's very difficult to carve a line to differentiate what is a customer's intellectual property and what is your intellectual property. So by and large, it is treated that whatever is there, it is customer's intellectual property. So in that scenario, it became very difficult. And again, you need to keep sure that once your engagement is terminated with a customer, you still have the manpower, and that manpower still have the knowledge which they have gained from their customers. So how to make sure that they do not do something which may end up in a breach of intellectual property with your customer. So it's very tricky and it's very difficult, but it is at the same time it is very important to have a proper IPR strategy for technology service companies, because if you don't have, then you will keep depending on the work from other companies, and ultimately, there would maybe a time when you do not have work, but you still have the manpower, and you will not be able to support the manpower. So I stop here. Lakshmi, back to you.
Thank you, Faisal. You brought the right point that the IPs are created for your customers, and then balancing the business relationship vis-a-vis handling of IP information becomes very important in your context. What we heard so far from Pragya and Faisal is the intellectual property business risks as well as the business relationships. Those become important points. This year also marks the 25th anniversary for the TRIPS agreement and the WTO agreement on IP. Let us hear from Anthony. What's there for our countrymen? What's there for this world to learn from these agreements on the importance of IP? Over to you, Anthony.
Thank you very much, and good morning to all. Indeed, it's been a fascinating period, this 25 years. With a colleague well known in India, Jayashree Wattal, I put together a negotiating history of our agreement, the TRIPS agreement, which is the WTO agreement on intellectual property. And its negotiation was, I have to say, quite controversial. There were questions about whether issues of intellectual property and patent law should be part of, or at all, whether the future World Trade Organization should include provisions on intellectual property. That in itself was controversial. And then the question of patents and establishing agreed international standards on patents was also a very difficult point in the negotiations. However, as you've mentioned, the TRIPS agreement, our IP agreement, came into force 25 years ago, a generation ago. And since then, we've learned a great deal in practice about the role of the patent system and its significance for development. And indeed, it was the TRIPS agreement that for the first time articulated in international law why we have a patent system, the policy reasons for having a patent system. And it expressed it very clearly in terms of promoting innovation, yes, but also ensuring that the fruits of innovation are shared and that there is a balance of rights and obligations. And the patent system is there to promote social and economic welfare. So a great deal of the discussion and sharing of experience over the last 25 years of implementing the TRIPS agreement has been about exactly how to achieve that in practice. So it's become less a debate about, okay, will we have a patent system or not? Is it good or bad? What side are you on, as it were? And a much more nuanced and empirically founded conversation about how to make it work effectively. What are the policy lessons from implementation? And we in Geneva, where I work, we work very closely with colleagues in the World Intellectual Property Organization as well, which is obviously is the lead agency internationally for intellectual property, to develop a really profound understanding of how the patent system can operate to promote that social and economic welfare, the promise that is made, if you like, in the treaty. And in that time too, the statistics have been quite remarkable. We have seen the centre of activity for the patent system shift from a focus on North America and Europe, of course, the traditional centres, to Asia, which is by far the most dynamic region currently in its use of the patent system. And the statistics are quite remarkable. It's a signal that in important emerging economies, the patent system is increasingly being deployed to build up innovative capacity, to transfer technology, and to transform the economies in an environment in which the knowledge economy is paramount for social and economic welfare. I think we'll touch on the specific issues in the course of the discussion, but I have to mention that the question of the health sector is, of course, by far the most sensitive when it comes to understanding the impact of the patent system, and indeed it's been one of the most sensitive areas in the discussions about the TRIPS agreement and public policy, for good reasons, because it is a central factor in determining that firstly we have the necessary innovation, fine, but also ensuring that there are guarantees that the fruits of that innovation, the benefits of innovation, are fairly and equitably shared and are made available, as we experience now, in the most extreme situations in terms of a pandemic. So there are still very important lessons to be learnt, and these are real lessons. This is not an abstract or political discussion. This is a very urgent, practical discussion, and I think we'll touch on that in the subsequent discussion. But I hope that I've sketched out the broad trends we've seen. Firstly, a greater recognition of the public policy role of the patent system, and understanding that it is there as part of the economic development toolkit. And as a tool, it has to be used and developed in a very skilled, judicious way. And so much of that depends on the human resources, the capacity to make use of the system. And we've seen a transformation in that human capacity in the developing world, particularly in the Asian region. And that in itself is a signal that the patent system is going to be used ever more effectively as a tool for development. And coupled with that has been a major shift in patenting activity from a traditional focus in the North American and European context to seeing Asia as increasingly the dynamo of innovative capacity and effective use of the patent system. But they're the broad trends that we've experienced over these 25 years.
That's wonderful, Anthony. Anthony brought out the point that the international harmonization of patent procedures and policies have been there. They are all not recent. It has been running for nearly 45 years. That's really great to know. And there is a high drive for promotion of innovation across the world, and there is a shift from the Western nations to even the Asian regions. There is a well-established public policy today, and there is less debate on the need for patent, but the debate is more about how do we use it effectively, how do we implement it effectively. Let's ask Bhavna, given that at the global level, A lot of activities are happening, public policies are evolving. Do you think our small scale industries are really utilizing them? How do they handle IP management? What is your view about how should they do and what costly mistakes they should avoid? Over to you, Bhavna.
think there is. Sorry, there was some lag happening in the interference. So yeah, I'm sorry. So
Okay.
yeah, now it's audible. Uh, So we have seen a shift, a remarkable shift from the traditional economic models to the knowledge economy. So it becomes very much important for the small scale industries as well to visualize and identify their IPs and protect them. Surprisingly, what I have seen that the IP prominence of the small scale industries is very less. In spite of that, India caters this industry at a very larger level. So we have to create some kind of a promising plans and understand the concern areas related to the protection of IP in the small scale industries. And we can understand this in two main headers, which I would say the investment and the budgeting. Second would be the protection of IP. So for the first point, which is the investment and budgeting, it is very crucial for the small scale industries because they don't have much of a scope to take the financial risk. So they can at least allot some kind of a budget at a very initial stages, and that can be among the top five spends of the small scale companies. So once the budget is already allocated, they have to align their IP needs with their business objectives and accordingly focus on obtaining the IP important for them. This would help the small scale industries to save the unappropriate expenditures, which mostly happens without having any kind of a plan or a foresight to it. So if I talk about the second point, which I mentioned, it was the protection of IP. Once you have allocated your budgets, now you have to identify what kind of a IP you should look into. So according to your industries, if I say just for an example, if I have a biomedical industry and I am working on some kind of a biomedical devices, so broadly, I do see three type of the IPs in the devices which I am creating. First is a trademark, which I will use to popularize or market my brand, that would be my brand name for that particular implant or the biomedical device, and patent for the technology introduced in that biomedical device, if it is novel, new, or having any kind of a technological advancement. And the last one would come, I should look into if I have any kind of a look and feel for a particular biomedical device, I should go for the design protection as well. So in this way, you have to structure your scope of the IPs, which IP you should opt for, or what kind of a IP you should leave for. One particular concern which I have always noticed while dealing with the small scale industries is that whenever they come to us, they say that we have already disclosed the inventive part of our invention to vendors to through any of our social media for the publicity. So in case of the patents, it is very important that you should not have any kind of a disclosure prior to filing of a patent application. So because this leads to your novelty is destroyed, and which is a prime criteria, which is one of the prime criteria for having a patent. So the next step would come in the IP management is the analysis and the auditing of your IP portfolio. Once you have filed many applications in trademark designs or patents, you have created a IP portfolio for yourself. And but by the time, particularly in the patent or a technology side, the inventions are not important for that particular time, or either the invention is obsolete that time. So in order to curtail your investments on that particular technology, you have to have a regular audits, and so that you are not going to invest unnecessarily on such kind of technologies which are not important that time. This analysis also helps you to understand the evolving needs and the demands of the market, and focus your R&D accordingly. And another major concern which I have observed is that the small scale industries are generally more into, I would say, for them, the legal aspects are non-significant for them. It's totally secondary for them. So they don't have any kind of agreements such as non-disclosure agreements or the contracts in place with their employees, vendors, agents, or any kind of a third party with whom they are dealing with related to their inventions or any such kind of a confidential information. So the small scale industry should start focusing on such kind of a legal compliances as well. And this would help them to reduce the risk of a leakage of the confidential information. The very important part which comes in, once you have IP, you have already filed applications and you are proceeding with them. There is a time management needs to be done, because as per the statute, there are very strict time limits which you need to follow once. And particularly for the patent side, if I say, there is no remedy to if any kind of a deadline is missed. So if that is not happen, then your patent or any IP is on risk actually. And the last point I would say is that you need to have the qualified IP advisors with you. So if you see the big industries, they do have dedicated IP departments or dedicated IP lawyers who take care of their IP portfolios. So otherwise, if that is not the case, then I would say your IP, your efforts all are in danger. So as in small scale industries, these are the very basic points one should take care of. Uh, Thank you, Lakshmi.
Thank you, Bhavna. I think all the speakers so far spoke about IP owners investing huge budgets, taking a large amount of risks in the investments. They do compliance. They make sure that there is an audit process. There is a proper information handling. So much of care is being taken because IP is important for everybody. And there is also the IP is subject to risks due to counterfeit. Given that IP owner makes a lot of efforts to protect the IP as well as comply with the government regulations, there is also one factor which is very important, and that's called national interest. Let's ask Dr. Akil, does this mean to IP owners? What is the importance of this national interest, and how the IP owner should deal with this? Over to you, Akil.
Thank you. Thank you, Lakshmi. And this is a very vital point about the national interest, which in legal terms we call perhaps compulsory licensing with reference to patents. Um, so far, India has, in my experience, tested compulsory licensing under national interest only for pharma. The rules and the regulations that you see under the patent regulations and under the IP laws, they are pretty much very, very broad. So, it does say that, any patent which has not been, put to use in India where the price of that product is exorbitant, and things like those. So there are three parameters which needs to be tested, and that has never been exploited before, although registered. So we have seen an instance of Natco Pharma where under compulsory licensing they did acquire a patent from Bayer, that was for a cancer drug, and the case that they could put out was that Bayer was selling the same product at a very very high price, I think about 280,000 rupees versus about 8,000 rupees that Natco Pharma projected that they can offer the same drug should they have a license. And they did, I think, apply for a license with Bayer, which was refused. So they did put up a case under a national interest that, Indian patients in India who need to be treated cannot afford such a high price of medicines. And as a result of which they were granted a compulsory license under the national interest. But my point is a little broader, Lakshmi. I think, and after that, there have been a few instances where some of the pharma companies have tried to acquire compulsory license in the same logic that Natco Pharma put across, but they were not successful. But this is one territory which is purely, although there is a provision, but in India, we have not seen this to be tested very, very effectively as to how, under a national interest, can the patent be shared with the manufacturers. But under COVID, what I see is the moment there is a formulation which a drug manufacturer develops internationally, I'm quite it will be very interesting to see whether pharma companies in India, whether they do their own development or whether they would be, and given the size of the infections that we are looking at, we are already over 5 million cases in India and rapidly growing. So that would be one area under national interest, whether somebody, AstraZeneca or other manufacturers, when manufacture or obtain a patent on the COVID-19 drug, how under national interest that will be tested before the court or before the patent regulator as to the grant of patent. So that is one area under pharma. But there are so many other areas. For example, in the ITES space, a lot of patents are being obtained, say by Microsoft, by other Adobe, by other major software or tool manufacturers who may have registered those patents in India. It is only a question of time when somebody puts up that kind of a petition of granting those patents, although registered but not being used with the national interest. So that will be very interesting to see as to how many industries of that nature. It could be aviation, it could be defense, but that test of national importance needs to be proved and acknowledged. But it's a very important provision under the Indian patent regime. I have also read that there have been very divergent views internationally in terms of this must provide kind of a provision wherein a patent holder could be directed, if there is a case for national interest, to share the patent rights. One of the very important things, although not directly related to patents but also related to intellectual property, was when I was the general counsel for Disney. Uh, a lot of channels were being downlinked from outside India into India, and the TRAI and DOT came up with the regulations of must carry, must provide. So if I am a distributor, whether it's a Tata Sky or whether it's a distribution model through analog cable systems or through satellite transmission, there was a provision under the DOT and TRA provisions that those channels should be shared, and especially related to sports channels, where the sports channels, it was mandated that whatever is being, say, a Star TV has IPL rights, so those intellectual property or the rights related to broadcasting should be shared with Doordarshan, which is the national broadcaster, and vice versa, that whatever channels the Doordarshan has, there were I think about 16 17 channels that should be carried compulsorily on the distribution platforms. So this national interest debate related to IPR is very interesting, and it is only a matter of time. So where companies will like to and India is a vast country, 1.3 billion people. So it's only a question of time that one is able to exploit legally a provision that it is needed for national interest, for various examples that I gave, and then exercise those rights legally to obtain those IPRs as a must carry, must provide. But thankfully, those instances as of now are very few and only related to pharma. But it will be very interesting to see from a general counsel's perspective. If I am a general counsel of a, say, a big IT company, and if somebody were to obtain my patent with a minuscule royalty, and by the way, in Bayer, what we see is the royalty was just about 6%, vis-a-vis 280,000 rupees for the drug price of the drug. So it will be a very interesting strategy how these companies should keep on, either for pharma, I would like to say, for example, big pharma companies to continuously exploit or commercially test those drugs in India through either through a generic manufacturing or their own manufacturing, so that at least one of the three criteria of compulsory licensing under national interest could be blunted. But that is a strategy. It will only how it comes into play will depend upon case to case basis. So I believe that under IP regulations, national interest and compulsory licensing are very important and interesting subjects.
That's wonderful, Dr. Akil. I think it was good to know your points on the IT-enabled services industry and also about the pharma companies. What is interesting is in the name of national rights, sorry, in the name of national interest, compulsory licensing is enforced upon the IP owners. And using the same compulsory licensing, there are a lot of competitors making attempts to acquire the rights from the IP owners in the name of compulsory licensing. And you made a good point that it's going to be very interesting to see the developments of this compulsory licensing, especially during the COVID situation. Let us ask Anthony, now that a lot of policies are in place to encourage innovation and provide exclusive rights for the IP owners, when it comes to the matter of national interest and then compulsory licensing, especially in the public health sector, what is your view, Anthony, is the interplay between offering exclusive rights and managing also the public health in the name of national interest? Over to you, Anthony.
Thank you very much. And of course, extremely pertinent and very practical question today. I have to say, when we speak of national interest, I work for an intergovernmental organization that comprises 164 national governments, and I'm a servant to those 164 governments. So as you will understand, there's a huge diversity in perspectives across that membership. Rightly so. There's a very rich and active policy discussion on these questions. However, I can say very clearly that there is a high degree of convergence on these matters, because in the wake of a previous pandemic or an ongoing health crisis, the HIV/AIDS epidemic, WTO members reached consensus on framing the international rules on IP, the TRIPS agreement in particular, within the context of public health. And here I'm referring to what we call the Doha Declaration on the TRIPS agreement and public health. This was agreed in 2001. It was a consensus agreement on the part of all of our members, and it's still a very important point of reference for us. It recognises that the patent system and TRIPS agreement, our intellectual property agreement, don't exist in isolation from public policy, but rather need to be understood within the context of public policy, and in this case in particular, public health policy. So from that point of view, the Doha Declaration, I like to say it provides the most succinct textbook in patent law that exists. In just 2 sentences, in paragraph 3, it says, "We recognise that intellectual property protection is important for the development of new medicines. We also recognise the concerns about its effect on prices." There you have, in a nutshell, the essence of patent policy debates and discussions that in the common law legal tradition quite literally date back to 1623 in the Statute of Monopolies, which was the first legislation that spelled out precisely the framework for the patent system that we know today. That's exactly the question. And the Doha Declaration then goes on to say that the TRIPS agreement does not and should not prevent members from taking measures to protect public health. And then it proceeds to elaborate some of the specific policy issues or policy contexts. And this includes a reference to compulsory licensing, the measure that you've mentioned, but also other areas of what are called flexibilities or policy options. And I think the important point to take away is that the patent right as such is not an absolute right. It's a right that is granted, administered, enforced, regulated within the context of public policy. Compulsory licensing is one of the mechanisms that can be used to adjust that right, if you like, or to take account of the public policy, but it's by no means the only one. And our current role as an intergovernmental organisation is to support our member governments in navigating the full range of public policy options and mechanisms to understand the full scope of the options that governments have within the international framework. And in doing so, we are in close partnership with the World Health Organization, the WHO, and the World Intellectual Property Organization, WIPO, because firstly, it's too important to deal with such an issue with these specialized agencies in isolation from one another. But secondly, because it's important for us to pool our different areas of expertise to provide the most comprehensive and integrated support for governments. So just in July, we together published what we call a trilateral study, an overview of the full range of policy choices that the member governments have in navigating the complex area between public health, intellectual property, and the trade system, to provide a platform, an information platform, to guide governments, to provide the support for governments that they need in making these choices. So, yes, as you've mentioned, as has been discussed, compulsory licensing is one of these measures. It's also addressed in the Doha Declaration. One of the functions of the Doha Declaration was, in a sense, to bring to light some of the principles that were implicit in the TRIPS agreement, to make them clear. And there is a reference in the Doha Declaration to the right to determine the grounds for compulsory licensing, for example. That's there in the declaration. It's not controversial. It's an agreed political statement by all of our members. But the real challenge is, of course, looking at all of the available policy tools and making them work in many different contexts. And of course, our membership range from small, isolated countries with extremely limited resources to the most technologically and wealthy countries on the planet. So there are, of course, a real diversity of options and different domestic circumstances. So our role is not, of course, to prescribe or lecture to our member governments, their sovereign nations. Our role is rather to provide a platform, an information platform for policymakers to work from. And in doing so, it's absolutely integral to our work that we cooperate closely with our international partners, the World Health Organization, World Intellectual Property Organization, but also regional organizations and, of course, national governments. This is a vital part of our work. That's probably an overview of what we're doing and how it functions. And I would really encourage anyone with an interest in this area to look firstly at the Doha Declaration. This is more than just a political declaration. It really has shaped our work. It has precipitated a very important collaborative, integrated, holistic approach on these issues. And secondly, to look at what we call the trilateral study. Trilateral study is an information platform updated to take account of the COVID pandemic. And that, I think, illustrates, firstly, the need for a holistic approach, and secondly, for a tailored approach that responds to the distinct circumstances of each nation. From that point of view, the situation in India, the policy process in India is of enormous interest to countries across the planet. Sometimes there are elements of controversy, but as I've mentioned earlier, what we really see now is first an appetite for a policy-rich conversation. And in our work in the WTO, we have a council called the TRIPS Council, which is the main intergovernmental forum for discussion of these issues. We've seen a really valuable conversation among our members who are informing each other about the steps they're taking to deal with the COVID pandemic, both in terms of promoting innovation and guarantees for access to vaccines and treatments when they're finally available. This has been a really informative and I would say collegial discussion among our members, each of whom are keen to learn from practical experience. And indeed, we are now collating this material and publishing it as a resource, as a means of providing factual, practical information about the range of options that are available. I would conclude also by saying that there's been a reminder in this process that patent rights are indeed exclusive rights. They are legally, they are a right to exclude, but the way the patent rights are exercised, are managed, are licensed, exhibits enormous diversity. And we have seen from the beginning of this dreadful pandemic, we've seen very encouraging signals from all sorts of key players in the private sector, in the public sector, the philanthropic sector. We've seen a lot of interest in developing models for sharing intellectual property, for ensuring that it's possible to package together intricate inputs to produce collective solutions. And that's been really striking from the beginning, that a reminder that how patent owners choose to exercise their rights can exhibit enormous diversity. And indeed, there has been a very encouraging signal that the key players are looking for appropriate ways of sharing their IP. We'll see when we have, of course, concrete products that are in enormous demand. When there are vaccines available, when there are proven treatments available, and of course there will be enormous practical hurdles to surmount. But I think I can at least say that we are working from a much richer foundation practical understanding, and second, strong signals of willingness to share and cooperate. While it'd be foolish, I suppose, to sound too optimistic, and certainly there's been a lot of encouragement so far. Thank you.
That's wonderful, Anthony. You made our day today by bringing the point that in the Doha Declaration, what is emphasized is innovation should be promoted, but it should be affordable. And the price of the innovative products must be reasonable. And the patent right is not an absolute right. That's the point that you try to hammer today. That's very, very important for all of us to know. Now that we are talking about not just public health and this compulsory licensing, like how Dr. Akil mentioned, is now spreading on to even non-healthcare domains. And the IP owner cannot remain, the IP owner cannot remain without commercializing, nor he cannot have unreasonable prices for his product. In this situation, let us ask Bhawna. Bhawna, in the interest of time, what is the top most strategy do you think the small industries must adopt, be it commercialization or be it enforcement? What is the top strategy in your mind that the small scale industries must adopt? Because we have been talking about more complex subjects. And what Anthony mentioned is 164 companies are coming together to collaborate and make the whole law harmonized. Do you think our small industries are at least aware of what is happening in this world? What strategy they should do? Over to you, Bhavna. Let us have one
Yeah.
topmost point and then we will switch topic because we have a little bit a longer way to go. Thank you, Bhavna.
Yes. Lakshmi, it is, you very well said that whether the small scale industry is aware of such kind of a commercialization or the enforcement part. As earlier I discussed, even the small scale industry has very less contribution into the patent filing systems. And even if we go through the annual report, which was published by the Indian Patent Office, the number of the patent applications was not more than 500 applications in a year. So the concern is huge in that respect. But if I go forward, if someone is already having the patents or any kind of a IP, it is very important for them to enforce them and commercialize them. And they have to understand, yes, the IP is an asset and it is not just a mere investment. And if I say, definitely it gives you industrial competitiveness in developing and launching the innovative products in the market. It gives you a different level from those who are not having a patent or any kind of a IP which is related to that product or the process that you are having. And if I talk about, see, the enforcement is a thing which anyone can have on their products or the processes when you have an IP, right? And particularly for the patents and designs, it is very important to have an IP because there is no remedy which is called as the passing off, right? Which is very well can be availed in the trademarks. So definitely, otherwise the technology or the design that we are talking about related to any of innovation, it will be in a public domain and you cannot have claim over it, right? If it comes in the public domain without having IP protected on it. So what the patent holders can do, they can be very well vigilant about what the industry developments are going on. And they can have very regular watch they can keep on their competitors. For this, they can have either through by themselves, as I told you, they can have in-house IP advisors, which can let them know, yes, there is something which is coming up in the market, which is just similar to yours, and it may be an infringement. Accordingly, they can issue the cease and desist notices to them, to the unauthorized users or the infringers. And if the cease and desist notice doesn't work for them, they can definitely go to the courts and file the legal suits against them and even claim the damages for the infringement by the third party. So, if I talk about apart from the enforcement, particularly for the MSMEs, because as I told you, they are on the very low budgets. They cannot have much of a risk on the financial part. So they can, for the commercialization, they can go to various government established PFCs are there. There are the technology transfer institutions are there already by the government. And to name few are like Technology Development Board, which is a part of DST, Department of Science and Technology. They help the innovators and the small scale industries to commercialize their patents. They help them in technology transfers through licensing, which can be of any kind, like exclusive or non-exclusive or the cross licensing. So there is one more a particular program which is very recently run by BIREC, which is the program is called as the National Biopharma Mission. And under this mission, they are particularly helping the industries which are in the biopharmaceuticals or into the biomedical devices. So, or if see, we always talk about the commercialization, and my talk would not be complete if I don't give any kind of an example to them what kind of a benefit a IP holder can have through their protected IPs. So there is a very interesting example which I just went through a few days back. It was There is a device which is called as a Raksha Kavach anti-collision device. This device was innovated by an individual, which later on established a small scale industry. And this device is particularly a GPS device, which enables in determining the train collision risk actually. And a study was done on the protected IP of this, which was a patent by the PwC. And it was estimated that there is a potential royalties which can be gained through this particular patent is 1 million billion US dollars. So I would say this is very important, not just to have an IP, but to have a to commercialize it and having support from government organizations therein or the IP advisors in this regard. Thank you.
Thank you, Bhavna. I think you placed the point rightly. Having designs increases the business edge. Having patents gives even higher competitive edge to the IP holders. Beyond this, there are trademarks, copyrights, and many other intellectual property forms. Let us ask Faisal quickly about how the other forms of IP are relevant in the given context. Faisal, over to you, Faisal. We just need 2 points as a takeaway why other forms are also relevant. Over to you, Faisal.
Thank you, Lakshmi. I think Bhavna has put up most of the points right in place. That it's important to have multiple types of intellectual property right protection around your product or solution which you are offering. Uh, the important point, Lakshmi, which I believe is that it's also important to identify when you need to start or when you need to apply for these rights. Patents, the moment you file the first patent application, a clock start ticking. You need to have to take care of strict timelines. You need to look at, you need to identify when you need to file that same application in other countries. or you wanted to take a PCT route or a conventional route to secure protection outside India. In case you fail to meet the timeline, then you may end up losing the IP protection all around. At the same time, the trademark protection is by virtue of its usage. So even if you have filed a trademark application early in the game, it may not matters much because unless you start using it in the market or start using it in your service line, then the protection will still remain. So the time is of an essence to determine when you wanted to file a IPR protection with respect to, or what kind of IPR protection you wanted to acquire with respect to your innovation. And the second important aspect is you need to align your IP strategy with your marketing strategy. If you simply start procuring IPRs and you don't align it with your marketing strategy, then there would be a disconnect. Um, what I've seen, particularly from Indian context, is that you file a patent application and then you sit back and you feel that you have done enough, and now you will start getting a good amount of royalty or money or whatever benefits you want it to. But it's not like that. You have to have a different set of IPRs around it, and you have to align it with your marketing strategy. Um, Akhil and Anthony already talked about, you have to make your innovation or invention accessible to the masses. So you have to work towards all of that so that you can have a successful product in the market. Once you have the product in the market, once you have a right IP strategy aligned with your marketing strategy, then definitely the other type of IPRs like trademark and copyrights kick in, and you need to have a right trademark strategy also. We have seen many companies, sustaining having a right trademark strategy and extending the protection for their innovation in the market. Classic example is Dolby. Then Coke is another example. So these are the companies which have sustained their innovation in the market by extending the protection, by having a right set of strategies around their IPS. I will stop here. Uh, Back to you.
Thank you, Faisal. From Faisal's view, we can understand that there is a lot of management thinking goes into the making of efforts, spending time, and also investing for acquisition of IP. With all these in place, we also spoke about the exclusive rights that we get after all these efforts and thinking is not going to be absolute. And beyond this, we spoke about national interest on the IP. From the IP owner's standpoint, or it could be government standpoint, or it could be any small private company's standpoint. Let us ask Dr. Akil, is there a remedy available if, as an IP owner, being compelled to offer license under compulsory licensing scheme? Over to you, Akil.
Absolutely, Lakshmi, that's a very valid point that since companies invest a lot of time, energy, and effort to develop an IP in whatever industry they are working on, um, and then they develop an intellectual property, whether it's a patent or other form of IP. Uh, Through compulsory licensing, at least it should be acknowledged that whatever, so there may be a direction by a patent controller, there may be a direction from a court, there may be a direction from a regulator that under national interest the IP will be acquired. But the commercial side of it should definitely be balanced. Um, so what we say that the patent owner or the IP owner should not unreasonably withhold sharing of the licensing, but it is very difficult to define what that unreasonableness or reasonableness is. So there has to be a mechanism, and whenever such orders are granted in against IP owner that they have to share because of a national interest, uh, the person should be adequately compensated, and that adequate compensation, should be a determination of a very judicial exercise or a commercial exercise, wherein it is determined that depending upon the profit margin of the company or how they are monetizing their IP, so a person should be compensated well. It should not be that under national interest, we should say that we want to squeeze the rights of a patent or a IP holder without adequately compensating that organization. So I would strongly recommend that whenever such kind of directions are passed, at least usually I would think the court or the regulator would say that the parties may determine whatever is adequate compensation. I would not like to see that um, it should be a price which is mandated by a regulator. It should be a commercially acceptable uh, royalty arrangement or a commercial arrangement. I can give you an example. So when we were looking at these downlinking of channels and the bouquet pricing, say for the distribution of channels by the distributors, the DOT and TRAI had put up a price, which means that not more than 1 rupee per subscriber for a particular channel. And there was a huge concern by the content developers like Disney, like Fox and others, that how can you put a price to my IP without looking at what cost did I incur to determine the price of my channel. So there was a strong advocacy at that point of time that there should be a free market. So I will provide my IP to you for distribution, but that price should be a market driven price. So if somebody wants my IP, pay me the commercial price and then distribute. But when we are trying to achieve a balance, it's a very difficult thing. But ultimately, there was a TRAI and a DOT order that no more than rupee 1 or 5 rupees per channel or a bouquet price. So they mandated a price. But through such mandated price, an organization may be commercially disadvantaged. So we have to work on a model which works for the commercial interest of an IP owner, because unless you compensate them adequately, uh, that desire to innovate will be lost. So there has to be, so every company cannot innovate. A company will only be able to innovate when they have the right type of people working on a development, and the right type of people come at a cost, and that cost is usually higher than the other individuals in an organization. So if a company like a Disney or a Microsoft or others are innovating, uh, they should be fairly compensated in a situation when it's a compulsory license, in a situation when it's a national interest. So that kind of a model should also be thought about as to what that compensation should be. It's a difficult question to answer, but certainly there should be a mechanism to ensure that the patent owner or a IPR producer gets compensated effectively.
That's wonderful, Dr. Akil. You drove the point that there is a desire to innovate because there is a need, and there are harmonization of policies and mechanisms. Do the IP owners get adequate compensation? Is a big question in compulsory licensing. Added to all these, we are not going to stop innovation. It's a continuous process. Let us ask Pragya, what initiatives the UK Intellectual Property Office is taking to promote research and innovation? Over to you, Pragya. You can give top 2 initiatives that our audience can take home today. Thank you, Pragya.
Yes, thank you. Thank you, Lakshmi. And I'm conscious that we are very short on time, so I'll keep it
Yeah.
brief. So first, I'll just briefly mention the wider initiatives at the British High Commission, and then come to how I offer support and how, by extension, the UK IPO offers support. So we have different teams here at the British High Commission leading on different aspects of technology, science, and innovation. In fact, we have a UK-India tech partnership, which was announced by Prime Minister Modi and the then UK Prime Minister Theresa May some years back. So the tech partnership works both with the Indian government and the private sector to increase tech investment and research and development. And the main aim is to encourage innovation and productivity by helping both Indian and UK businesses collaborate on emerging technologies. Then we have a science and innovation team which works to influence science and innovation policies of the Indian government, industry, and academia, and to improve UK policy based on international experience, and to harness strategic science collaborations with India. And one key priority area there is public health and well-being too. Then we also have a recently launched £3 million Innovation Challenge Fund, and that is to specifically support scientists in academia and the industry to tackle a couple of challenges. And COVID-19 is one of those challenges, and it invites uh, bids from tech innovators to submit research and development proposals in these areas. Then we also have a separate life sciences and healthcare team which works on different aspects of healthcare and life sciences. Now, tying all this together, how does the UK IPO come in here? So, as attaché, one key strand of my role is to work closely with different sectors in their work with an IP interface. And this support can be in the form of consultation in different projects that I just mentioned, issue specific advice on IP, and also policy support through government discussions in areas that are of concern to a particular sector or a particular industry. Then, following up from government dialogue, I would also like to mention the recent Joint Economic Trade Committee, that is a government to government dialogue between UK and India, and it is focused largely on market access barriers and including IP. So the recent virtual JETCO in July, it just concluded in July, and UK and India issued a joint statement saying both countries will continue to work in partnership with industry to develop and strengthen the positive impact of a strong IP system that protects and rewards innovation and creativity. And this includes the initiatives that we already have under UK IPO's existing MOU with the Ministry of Commerce here in India. Then UK and India are also seeking to develop an enhanced trade partnership between the two countries, and IP is a key part of those discussions. So the IPO also feeds into these policy related discussions. Then I would also like to briefly mention the Lambo Toolkit, which is a toolkit to facilitate industry and academia collaborations in research and development. And it has been previously very successfully used in the UK. And we are consulting with a large number of stakeholders here in India and the UK counterparts who collaborate with Indian entities to do an India adapted version of the toolkit so that it can guide research and collaboration agreements. Thank you.
That's good to know, Pragya. I think the highlight is about the tool that you mentioned, the Lambo Toolkit, which facilitates university industry collaboration. I think in another opportunity, the audience can reach out to Pragya to understand more about it.
Yes,
And,
definitely.
and there is also the consultancy support, the policy support, government interface, all these are available to promote innovation and research in the country. There is an audience question also. I would like to club that with the discussion point for Anthony. The audience question is, what do you think about intellectual property protection and growth in India 10 years from now? In sync, let's ask also Anthony, we are talking about a multilateral system and we are talking about promoting innovation, access, and when to see the fruits of innovation. So combining the points that Anthony has, how do we answer this question from the audience? Where do we see India 10 years from now? And where do you see the world of developing nations 10 years from now? Anthony has a bigger picture, which is the global perspective, and I hope he will be able to answer what will be the situation in India. Maybe after that, we can hear the views of our panel, other panelists too. Over to you, Anthony.
Thank you very much. And two very interesting questions that are indeed closely related. I would say, however, that it would be somewhat impertinent of me to comment on India's situation, given that the rest of the panel are all better qualified than me to address that question. But I will tentatively offer some thoughts, and I can do this on the basis of having worked both in my present position and in the World Intellectual Property Organization with India for many years. And looking back over that time, again, 25 years, the development of human capital, of expertise in India has been absolutely dramatic. And in the policy sphere, in the academic sphere, in the business sphere, India has emerged as a true center of knowledge and expertise. That's very, very clear, specifically concerning the operation of the intellectual property system and the intellectual property system as a policy tool. And that's a striking development. We are also seeing in the official statistics increasing use of the IP system in India. India is emerging as a player. Of course, other Asian economies have led the way, if you like, but I would be very surprised if the time frame you're given of 10 years, if India is not also at the top of the league table, as it were, given the underlying dynamics that have been so evident even in our conversations this morning. India has a remarkable human capital, remarkable innovative capacity, and is rapidly uptaking technology today. And so all of those factors are clearly pointing in that direction. But as I say, it would be impertinent of me to offer a view when I'm virtually surrounded by a panel with much greater insights than I have. The broader picture, you've mentioned the multilateral system and its future development. What I would say there is that the focus in the past has been on negotiation of new treaties. The TRIPS agreement we've discussed stands amongst those, of course. That will not. There will not be multilateral negotiations on intellectual property matters for some time, I would say. There simply just is not the political appetite for that. And I would say that that's, in a sense, maybe a good thing, because what we are seeing, as I've emphasized earlier, is a period of really concentrated learning and the pooling of experience, understanding in a much more informed and practical way, evidence-driven way, of how the system has been put to use. And that is a very active part of the multilateral work we are doing. It may not be as visible or as dramatic as negotiations, but I would say it's urgently needed and, in a sense, at this stage, more productive as well. Another aspect of the multilateral system is dispute settlement, and there's no doubt that disputation over intellectual property matters will continue. That's a fact of life. And we have seen the multilateral dispute settlement system managed by the WTO address a number of important public health matters. It's helped mark out the full scope for policy options that countries have to take care of public health matters within the context of the intellectual property system. And that I think that important role can and should continue. But I would emphasize again the value of the trilateral process, the cooperative process we have with the World Health Organization and the World Intellectual Property Organization, which it focuses on not on, if you like, lecturing to member governments or prescribing solutions, but rather providing policy support, providing an empirical platform for governments to work from, and providing the forum for governments to exchange their experiences. Our members range from micro countries, very small Caribbean Pacific countries, to major countries such as China and India, rich and poor countries. So the emphasis currently is on sharing that experience and understanding the way that different tailored responses can deal with specific national circumstances and priorities. And that is a very, very healthy conversation right now, and an urgently needed one. Future speculating completely, I would say that there will over time be need for new multilateral rules. And one reason for that is that there has been very active negotiation of new rules in bilateral and regional agreements. And over time, I think the complexity of those, the diversity of those, will require a complete rebooting, if you like, of the multilateral system to take account of those developments. But that's still somewhat in the future, and I wouldn't suggest that the political appetite is there for that right now. So I hope that gives some ideas of the future directions. And I would certainly once again encourage anyone with an interest to contact me, and I can ensure that they get a copy of the trilateral study I mentioned. It's just been out for 6 weeks now, and it does represent the state of the art in that multilateral cooperation and information sharing that I've been emphasizing. So thank you.
That's wonderful, Anthony. We are glad to know that India in the next 10 years is likely to top the world in IP creation, utilization, and also implementation of the IP system in a more effective way. That's very, very exciting to hear for us too. Not just that, it's good to know that the World Forum is continuously cooperating to improve the entire patent system in the developing countries as well as the developed countries. The other panelists, do you have any views on where our country will be next 10 years from now in IP creation, management, and enforcement of intellectual property rights? With that, then we can bring the session to the conclusion. Do you have any views, Pragya, Bhavna, Dr. Akil, Faisal?
So, Lakshmi, I would just like to offer a couple of things here. And Tony is very, very humble. His insights have been incredibly useful and helpful, actually. And I'm nowhere near as equipped to, offer that level of insights, but just a couple of developments that I wanted to share. So as I said, IP is increasingly forming a very significant part of these government discussions, these bilateral dialogues, and not just in terms of patents and healthcare, but in other sectors also, including enforcement, copyright, creative industries. So there are definitely some positive developments there. India is also rising in the Global Innovation Index rankings. This year, for the first time, India is in the top 50. So that's definitely a great development. And same is with the ease of doing business rankings. And I mention ease of doing business because how we see it, we see ease of doing business and IP as somewhat interlinked, because if we are successful in removing an IP related barrier to business, then it undoubtedly improves the ease of doing business environment in the country too. So there are positive developments on all these fronts. That's
So
it from me.
Lakshmi, Lakshmi, as I see it, if I look at my immediately previous four employers, let's start, with General Motors, which was in 2002, 2005. I was working with them. So that time we had set up a technology center in Bangalore for General Motors design and development of automobiles as a global source from India. It is doing pretty well, and I think they still are supporting the IP development from India. Then moving over from General Motors to Disney, where a lot of IP got generated in India. The problem in that industry is that India remains still not very good in terms of enforcement and IP protection. Although, the best in the international practices. Internationally, we have the regulations and treaties, but we have best of everything. But the enforcement remains a challenge, especially for consumer durables, consumer products, apparel, in that, and pharma. So that is where I would, in next 10 years, like to see a lot of development in terms of IP protection. We should also be similar to the developed countries, both in terms of IP enforcement and education. So that is one strong development area I believe is there. Then, when I moved to Fidelity, in Fidelity, there was a lot of technology and IT development for, the various funds that Fidelity managed globally. That time they were about $2.5 trillion assets under management. So from that point of view, I think we are doing pretty good in terms of other IT companies in India. Um, and then currently with Boeing, so aerospace defense, we invested about 4,000 engineers in India over last 4 years, doing a lot of civil aviation, commercial planes and defense innovations in India, seeking patents. So in terms of seeking patents development, I think India is doing, great. Yeah, but I think in next 10 years, the development area, as I say, should be more on the enforcement and education. And unless we do that, so coming to your original question that you had put for the small sector, they should also acknowledge the need to develop IP. And I think either it is lack of education, or the businesses do not realize the value, or they see acquisition of IP and then develop or commercially exploit that as a cost, that why should I pay royalty when I can manufacture it through a process, exploitation. I think those kind of things needs to be tackled very aggressively, so that we see a more robust IP development regime in India.
Add to what
Yeah.
the speakers have said, India have Bhavna, please you go.
Yes, Faizan. Yeah. Bhavna, do you have any point to share?
Yeah, yeah, definitely. I do have. I just want to add that at this point in time, I do see that the India is on the uh, upside momentum, and this is because now these days the ministries and the acts and the regulations which are deriving the IPs, and they are not working in isolation. The government is if I see the MSME, the ministry is some other ministry. They are helping out in the IPs to the MSMEs. There are many facilitation programs which are going on by different ministries to take up the IP. So this way, the governance is working in a collaborative manner. So they are not in the isolation. So this is making a huge difference. So, and definitely this would result that we are looking for. So this is the point that I wanted to share with you. Thank you.
We have come a long way. If you look at 10 years back, the rules and regulations which were there, the way the patent used to be granted, uh, we have evolved quite drastically from there. You know, there was this time when there was a lag of 7 to 8 years in granting a patent. Now we are seeing that patents are granted within a year or so. Definitely, we are moving at a very fast pace. But as Dr. Akil indicated, that we still need to have see policies which can enable better enforcement, particularly in patent enforcement. Uh, so that is one area which we need to work upon. But otherwise, as all the speakers are saying the same thing, we are moving at a very fast pace, and then definitely we will
Perfect.
be at the top level.
Thank you, Faisal. I think this has been a very great panel today. The perspectives are not ordinary. That is because we have diversity in the panel. Faisal comes from software services perspective, Pragya from the government interface perspective, Akil from the product company perspective, Bhavna from practitioner's perspective, and Anthony giving the global policy perspective. So combining all these things, all the views of the panelists, I could see that India has challenges. They are not very big, they are not very small. Yes, we do have challenges at the moment, either in policy implementation or like how Bhavna Anil Akil mentioned about acquisition of IT by the small scale industries. But the overall feel is that India is not very far from the global scenario. And there has been uniformity in the views of our panelists, and that there was a confidence level that was demonstrated in what they said, that in the next 10 years, India is going to be at the top, be it IP creation, enforcement, or utilization of IP. With this, we will conclude the session on the patents, the perspective of enforcement in global scenario. And we thank the audience for very passionate listening, even during a Saturday for the entire half day. And a special thanks to Anthony. This has been very early morning for him. Probably it has become afternoon for him too, since beginning of his day, for sharing his insights to our countrymen. Thank you all panelists. Thank you audience. And we must thank CII. We must thank Singhania and partners, the team. And I also thank Amrita of CII for having organized this conference, and also Jay Kumar for hosting all of us here with his IT support. I hope we had a great day today, and we wish you all the best with success listening to our panelists today. Over to you, Amrita.
Thank you, sir. Thank you so much. Thank you, audience, and thank you all the speakers and the moderator, and thank you, Singhania partners, for joining in association with TNTD PCCII for this wonderful program. And I wish the same success will be continued for all the future programs also. Thank you so much. Thank you, Kushbu. Thank you, Sana, and thank you, Bhavna.
The
Thank you very
audience can
much.
connect. The audience can connect with the panelists via LinkedIn for further information sharing, because we try to make the theme coherent and try to bring connection. We did not see much questions from the audience. If you would like to have more interactions with the panelists, please feel free to connect with them via LinkedIn, and then that must be a good engagement. Thank you, all of you. Thank you.
Thank
Bye
you.
bye. Bye bye.
Bye.
Bye. Thank you.
Thank you very much. Thank you. Thank you, Lakshmi. Thank you, everyone.
Thank you.
Bye.
Thank you. Bye bye.